The Clean Water Act is a law that has been controversial for many decades. The Foundation and its attorneys have participated in many cases concerning the scope of the Clean Water Act, including the Supreme Court's two most recent cases addressing that statute, Rapanos versus the United States and Sackett versus EPA. The recent controversy has focused, of course, on the scope of the WOTUS rule, but in my testimony this afternoon, I'd like to draw the committee's attention to issues that are not directly raised by the WOTUS rule, but nevertheless, in my view, represent the extravagance with which the EPA and the Corps view their authority under the Clean Water Act. I'd like to begin with a case that, Mr. Chairman, you mentioned in your opening remarks concerning the Schiff family in Alaska. The Schiffs own a pipe fabrication business, and they want to expand their business and acquire a new location for that purpose. But the Corps has intervened and asserted jurisdiction over approximately 200 acres of that property, calling it permafrost that is subject to the Clean Water Act. Now, no one disputes that determining whether a site contains wetlands can be exceptionally difficult. And to provide some measure of predictability, Congress in 1992 mandated that the Corps use its 1987 Wetlands Manual for delineating wetlands until a final manual would be adopted. Now, under the manual, it's clear that permafrost does not qualify as a wetland. But to get around that obstacle, the Army Corps in 2007 promulgated a so-called Alaska Supplement. This supplement changes a key criterion for wetlands delineation, which allows the agency to regulate permafrost. Again, that's a result that could not be reached under the congressionally mandated, nationally applicable 87 Wetlands Manual. Now, although permafrost is not that common in the lower 48, the principle raised by the Schiff family's case pertains throughout the country. Should a federal agency be allowed to deviate from its published, nationally applicable rules just to expand its power? The answer clearly is no. Another example of agency excess under the Clean Water Act comes out of Andy Johnson's battle with EPA over his stock pond. Johnson owns an 8-acre parcel in Fort Bridger, Wyoming. The rural property contains both his home as well as some surrounding land which he uses to raise various farm animals, including horses and cattle. Johnson obtained a permit from the state of Wyoming to construct a stock pond in order to improve the water quality on his property. Unfortunately, EPA didn't care for that, and in January 2014 issued a compliance order against Mr. Johnson, saying that his construction of the stock pond violated the Clean Water Act. This notwithstanding the fact that the Clean Water Act since the late 1970s has clearly exempted the construction and maintenance of farm and stock ponds from Clean Water Act regulation. Nevertheless, the EPA said that the Clean Water Act applied to Mr. Johnson's stock pond because he did not construct it simply for the use of his livestock, but also for the aesthetic pleasure that it might give himself and his family, and therefore because his intent was not limited to simply providing water for his livestock, the exemption did not apply. And the compliance order that was issued against Mr. Johnson not only told him that he had to undo everything that he had done, but also threatened tens of thousands of dollars per day in civil penalties if he did not immediately respond to the compliance order. Now, thankfully, following a lawsuit brought by Pacific Legal Foundation attorneys, EPA agreed to a reasonable settlement with Mr. Johnson, allowing him to keep his stock pond without having to obtain a permit. But there is no reason to think that the agency will not continue to enforce its very narrow interpretation of the stock pond exemption to farmers and landowners throughout the country. So in closing, I would just like to emphasize that regardless of the WOTUS rule's fate, the history of the enforcement of the Clean Water Act by the Army Corps of Engineers as well as the EPA demonstrates that, frankly, all too often these agencies allow a misguided zeal for protecting the environment to override key constitutional and statutory protections for the nation's farmers and landowners throughout the country. I thank you again for the opportunity, Mr. Chairman, and I look forward to answering any questions the committee may have.